Hi, welcome back. Let's talk about what happens after you've decided that there isn't going to be a settlement and you put your carrier on notice. So now you're going to have to respond to the lawsuit. You can either make a motion or you can file your answer. What does it mean, make a motion? A motion basically says, Judge, let's not get into this. The court might not have jurisdiction over you. We talked about that a couple of lessons ago. The court might not have jurisdiction over this kind of claim. For example, if it's a federal court and someone sues you for hit and run and you both live in Omaha, Nebraska, federal court has nothing to say about that. It's not an option for you. You're not citizens of diverse states making claims for over $75,000, which is what diversity jurisdiction would provide. We discussed that a few lessons ago. And there's no federal claim. There might be an arbitration clause. You might have agreed when you entered into the relationship, assuming that it's a pre-existing relationship with some kind of contract, and a contract can include user agreements for software, terms of service for websites, retainer agreements with law firms or other professionals, or any kind of other contracts. These may require you to go to arbitration. Courts will enforce this in almost all circumstances, as long as they're satisfied that you had the opportunity to not agree to it. That doesn't mean that you wouldn't have gotten the car or the brokerage services or the legal services or the operation or whatever it is, unless you agreed to the arbitration clause. That's a choice that you make. That's the deal that you make. So what we have now is you're stuck in arbitration with one judge or one arbitrator. Not much of a difference. And in fact, a lot of the arbitrators today are retired judges trying to make bank. That's something to look out for in contracts. As I said earlier, it's almost always put in there to make litigation by the party with shallower pockets less attractive. We do find ways to complicate things. While a motion to dismiss is pending, in most of the busier courts, the case goes on while the motion is pending. So if a judge finally gets around to deciding that the case should never have been filed in the first place, for all practical purposes, there's nothing anybody can do about it. That's ridiculous. And it's ridiculous, especially because very few of these motions really should take that long to decide.